Yes, Mr. Hogan.
My lady, my lords, I'm moving on to the law relevant to strikeout. Before I come to the case law, can I make just a few observations about the rules and how they're structured? And perhaps to begin with Rule 3.4 itself. 3.42 is divided into three limbs, A and B and C. And there is a distinction for the purposes of this case to be drawn between A and B and C. A and B cover what might be called substantive strikeouts, where a case is struck out under A because there are no reasonable grounds for bringing or defending the claim. A classic example is where someone pleads a duty of care, which is not recognised at law. B is significant because although they are disjunctive grounds, it links together the concept of an abuse of the court's process or otherwise likely to obstruct the just disposal of the proceeding. And the significance of otherwise is it's drawing, if not an equivalence, certainly a link between the two concepts. And C is dealing with procedural matters, failure to comply with a rule, practice, direction of court order. An obvious example would be breach of an unless order, requiring if something's not done, then the case is struck out. If one holds those three limbs in mind and moves to 44.15, the wording of 44.15 tracks but does not mirror Rule 3.4. And in particular, you'll see that sub-rule 3.42c, strike out for breach of orders, rules or practice directions, has no equivalent. And the consequence of that is that if your case is struck out because you breach an unless order or fail to pay court fees when they are due by operation of the rules, you do not lose your Quox protection. So the exception is narrowed to the two categories of no reasonable grounds or abuse of the court's process or conduct likely to obstruct the just disposal of the proceeding. So again, one can see an element of the purpose here in that there will be many cases which are struck out, possibly for repeated procedural default, but the claimant will still retain Quox protection. There has to be conduct of a relatively high level of egregiousness for that protection to be lost. The other point that I'd raise at this stage, because it finds some reflection in the cases we'll look at in a moment, is that 3.42b could be viewed as a codification of the court's inherent jurisdiction to strike out a case. Every superior court of record has an inherent jurisdiction to strike out a case if its procedure is being abused. And although the county court does not have an inherent jurisdiction, because of powers or provisions in the County Courts Act, it adopts the practice and procedure of the High Court, so that, for example, in the old days, you could dismiss a case for want of prosecution in the County Court, even though that was an exercise of the inherent jurisdiction. Now, the final point about the rules is to note that 3.4 falls within the wider context of Part 3, which is the provisions and powers the court has for the purposes of case management. It's not a penal provision. The purposes of courts is to try cases. In certain circumstances, that's not possible, and therefore, at some earlier stage than trial, a case can be properly struck out if that threshold of abusive process or conduct obstructing the just disposal of the proceedings is met. Now, with those thoughts in mind, moving to the authorities, the court has already been through the Arrow nominees case, but there are three further cases which have some bearing upon the scope of 3.42b. And the next one chronologically is a case called Masood and others against Sahur and others, the head note of which is at page 247 in the authority file. The facts of Masood and Zahur are again far removed from this case. It was essentially a contractual dispute, and whether someone was entitled to a shareholding or the value of a shareholding. But what is significant about the case when it reached the Court of Appeal are two particular paragraphs where the Court of Appeal considered the purpose of a strikeout and the test for a strikeout. The first of those paragraphs is paragraph 71 at page 251 in the authorities bundle. If I just pause for a moment there before making a couple of points about paragraph 71.
Who's this? This is the Master Earl speaking, is it?
No, this is Lord Justice Mummery.
Mummery, thank you.
Now, 71 is the judge in the Court of Appeal in Masood drawing upon the ratio of arrow nominees to say what it means. And the significance is in the first sentence, where the court says, in our judgment, this decision, arrow nominees, is authority for the proposition that where a claimant is guilty of misconduct in relation to the proceedings which is so serious, it would be an affront to the court to permit him to continue to prosecute his claim, and the claim may be struck out for that reason. Now that wording is different to the wording actually used in arrow nominees, but again, it's an expression of the seriousness or egregiousness of the conduct which is necessary around a strikeout. The second paragraph which is significant is paragraph 73, and again if I just pause there before making a couple of points from paragraph 73.
Yes.
73 harks back to this notion that this is a case management power. The idea of a strikeout finds its fullest expression in bringing proceedings to an end well before trial to stop the waste of resources. But of course, once you've reached trial, ordinarily, you get on with it and you make the findings on the basis of the evidence. And if that leads you down a certain direction because forgery or fraudulent conduct or something of that nature has taken place, then matters follow on from there. But again, the purpose of the strikeout is case management rather than punishment or disapplication of a particular set of cost provisions. Those two cases, arrow nominees and Masood and Zahur, preceded the very important case in the Supreme Court of Summers and Fairclough Holmes, which is at page 126 in the bundle. The facts of this case are slightly more congruent to this sort of litigation in that it was a personal injury claim. And it was a case where the claim put forward was fraudulent and exaggerated. Not that there hadn't been a genuine accident, but when the judge had finally tried the case, instead of awarding the £838,000 claim, it had awarded a figure of about a tenth of that, £88,000. There had been gross exaggeration. One of the issues in the case, however, was whether it was appropriate for the judge to have tried the case, of whether he should have moved to strike it out because of the nature of the conduct that was there. And there are three passages which are of significance. The first of those is 34 to 36. 34 and 35 in effect set the seed for the conclusional statement at paragraph 36. So it's paragraph 36 that expressly direct the court's attention to.
What is this about? This is about striking out at the end of a trial.
It is. And what the Supreme Court stated was that in terms of striking out set against determining the trial, they took the view that the court does have power to strike out, even if you are at the point of trial. But in addition to the high hurdle of abuse of process or something of that nature, they regarded it as a very exceptional course, and so added a further limb of refinement to the restrictions, if you like, adopted with respect to the strike.
But isn't this in the context of the trial having got to the end?
Having got to the end, yes.
What does that tell us about our case?
It reinforces the point that this is a very sparing jurisdiction, or a jurisdiction to be used very sparingly.
But this is not a case in which the court could have given the decision.
No. But
isn't this saying that if the choice is between giving a decision and striking out the claim, give the decision?
Yes. The point that I wish to put forward is that if strikeout is used primarily for case management purposes, then one can see that there's no point striking out a case once you've had the trial. Yeah. But in this case, again, we didn't have the trial, but the proceedings had still come to an end. So what is the point of striking them out, except for the improper purpose of disapplying clause?
But yes, but you had a right to discontinue, and they had a right to try to stop you. So I'm not quite sure where this takes us.
Well, if I come to the final paragraph that I wish to bring the court's attention to. It's paragraph 49. It's on a slightly different point, but it's a key part of the decision in Summers, where in paragraph 49, paragraph E, the Supreme Court emphasised that the draconian step of striking out a claim is always a last resort. So I suppose the point that I'm drawing together is that you have the point first flagged up in our nominees about the exceptional nature of the conduct that's required. You then have in the later cases the notion that strikeout is used as a tool of case management. It's not there for any other reason. And the third point, that because of the exceptional nature of the order, it's a draconian step and the order of last resort. So, drawing the threads together, where I wish to take the argument it can be summarised as follows. The first point is that there is no support at all in the authorities for any principle that simply to bring a case that is likely to be lost at trial falls within Rule 3.42b, quite the converse. The second point is if one turns to just a final paragraph of the authorities in the case of Howlett and Davies, which is in my skeleton argument, but can I just give you some context? It's the head note's at 202. No, forgive me, I've completely got that wrong. It's not Howlett and Davies. It's the case of Hughes Jarvis Limited, which is at page 254.
Thank you.
Forgive me, I can't read my own handwriting. It's paragraph 47. And I note that my lady sat on the division of the court in this case as well.
Yeah, I do remember this case. The facts were particularly striking.
Yes. Paragraph 47 was Lord Justice Patton's summation of circumstances giving rise to the exercise of the strikeout power. And what he noted in paragraph 47 at page 270 is that although the strikeout power does involve, as a relevant consideration, wider questions, such as the use of court time, proper exercise of the jurisdiction, usually depends upon conduct by the claimant or other party, which makes the conduct of a fair trial, and therefore the judgment of the merits, practically impossible. And then he references arrow nominees again. So the point that I would make is, again, a very high hurdle that has to be met for a case to be properly struck out. And finally, that I think it's now accepted that the correct construction or sequencing of the rules is that first a case is struck out under 3.4, and then you look to see what the Cox consequences are under 44.15. If this case had hypothetically been struck out for breach of an unless order, then the defendant could not enforce their claim for costs or any cost order in their favour. In relation to 44.15, it's merely a procedural gateway, but the substance of the case is whether the case was properly struck out under 3.4. Now, those are all the points I wanted to make about strikeout. You have my points about why this case cannot possibly have been properly struck out, given the high hurdle that had to be surmounted. Mr. Higgins, however, developed his argument that there should be some wider discretionary power to disapply quod. And in his written argument, he identifies Rule 3.12n in the Civil Procedure Book as possibly being a source for such power. Again, if one turns to the rule first of all, it's page 105 of the White Book. And it provides that the court can make an order to take any other step or make any other further order for the purpose of managing the case and furthering the overriding objective, including now hearing an early neutral evaluation with the aim of helping the parties to settle their case. But in my submission, this rule, or this rule in conjunction with any other rule, doesn't give rise to the broad discretionary power Mr. Higgins urges upon the court. The first and most fundamental point is that this is a rule dealing with case management directions. If one looks at the text of subparagraph M, it expressly says any other order for the purpose of managing the case. Well, this wasn't about case management, this was about costs and the enforceability of a costs order. Secondly, it sits within the broader scheme of Rule 3.1 and indeed Part 3 itself, which is all about case management, directions, or matters of that nature. And so, properly construed, the purpose of Rule 3.1m is simply to enable the court to make flexible directions which aren't catered for in the specific examples given in the earlier parts of the rule. And to that extent, it emphasises a point which has always been in the civil procedure rules, that there is flexibility in case management, taking issues out of sequence, focusing on what really matters in the case. But that's as far as it goes. The second point is what, in my submission, is a principle of general construction. Namely, that you may have in any given set of facts two rules which are apt to apply to it, to a given situation. The most obvious example, there is a general power in the civil procedure rules to extend time, but then there is also a further power to extend time for the service of a claim form. But it has always been the case that a general rule gives way to a specific rule which caters more tightly to the mischief of a particular situation. So, bringing that into our case, we have, in Part 44, in my submission, a comprehensive code of the only circumstances in which Cox will be disapplied. You are either within one of those exceptions, fundamental dishonesty, strikeout, whatever it may be, or you are not. And if you are not, you cannot prenade any wider provision. And the point which follows from that really is a matter of common sense, is if it were any other way, what is the point of having a list of specific exceptions if you could simply go straight to the heart of matters by saying you have a broad discretionary power? Mr. Higgins did raise the issue of fundamental dishonesty obliquely by reference to the Gosling case of His Honour Judge Maloney, Queen's Counsel in the Cambridge County Court, which was picked up in the case of Howlett and Davies with approval of the formulation by Lord Justice Newey. To draw out this phrase, is the claimant deserving of the protection of Cox? But the context of that phrase was really to pose the question, is there dishonesty here, or is there fundamental dishonesty here, which means someone loses the protection of Cox? It is entirely possible, as this court anticipate will appreciate, for someone to tell lies in respect of one or more issues in the case, but otherwise to give 90% honest and truthful answers. And the reason they tell lies may have nothing to do with the case at all. But that, in effect, sits in its own box as a tool for determining whether dishonesty is fundamental or not, or whether it's dishonesty which is not fundamental, in which case Cox would still apply. But again, it has no application to the facts of this case, where the court is grappling with what is conduct likely to obstruct the just disposal of the proceedings, and then whether that conduct is in any shape or form discernible on the facts of my client's case. So, in summary, on the three particular issues that are now before the court, in respect of the notice point and whether a discontinuance should be set aside, you have the Court of Appeal in Stati in Kazakhstan emphasising first of all what an exceptional course this is, and then the need for some discernible, legitimate continuing interest for the proceedings to continue. And that's simply not present on the facts of this case. This case died with the notice of discontinuance. Secondly, on the strikeout point, the authorities all illustrate what an exceptional course of conduct is required to commit an abusive process, to amount to an abusive process, or to obstruct the just disposal of the proceeding. And again, on the facts of this case, it's simply not made out. The reasons His Honour Judge Freedman gave in his judgment. And the third point, the prize that the appellant really seeks in this appeal, the declaration that the civil procedure rules give first instance judges a broad discretionary power to disapply costs, is simply absent from the rules, whichever rules you look at and whatever construction is placed upon them. Quox is a broad scheme with a limited number of exceptions, and they're simply not found in this case. Those were the points I wanted to make. I'm conscious that the division may have questions for me.
Just go back to your first point in summary, which was based on Stati, which was a rather particular set of facts.
Yes.
Can it not be said that the defendants here had a legitimate interest in continuance because of the costs issue? So why not referring particularly to this case, not referring to it at all, but in a case where a claimant was obviously looking down the barrel of a gun, having run a disreputable case, they then try and avoid the bullet by serving notice of discontinuance before they're shot. But why does the defendant not have a legitimate interest in reviving the proceedings in order to see a fair order for costs made? Appreciate you say that's not this case, but what's wrong with that is my question.
I'm glad you asked me that, because I was thinking about this over lunchtime. And when one considers what a discontinuance is, it preserves a claimant's cause of action. So notionally, you can start a second set of proceedings once you've discontinued. Why would a defendant want to set aside the notice of discontinuance legitimately? Well, they would want to bring the case to judgment so that there's an extension of the cause of action.
Or a strikeout.
Or a strikeout. A strikeout that can't result in resurrection.
Because that is the end of that claim.
That is the end of that claim. But if one then goes further, one has to say, in terms of the legitimacy of the interest, if the legitimacy of the interest is in bringing the proceedings to the end because the claimant is using effectively a statutory right given to him, the Quox protection, the defendant's attempt to take that away would not be legitimate. The defendant would have the practical interest in resurrecting the proceedings as the springboard for a strikeout application, but Parliament has given the legitimate interest of the claimant. And testing the matter this way, it might have been possible for Parliament to have said there is actually a further exception in Quox, that if you discontinue your case, then you will pay the cost.
Yes, but I understand all that, but what I'm referring to is not Parliament having given the right to a claimant to have Quox protection. But I'm talking about a case in which the defendant would wish to argue and avail themselves of the rules that permit them to say that this was an abuse of Quox protection. And so I'm only just testing one step in your argument, which is the assertion that a defendant can have no discernible interest in reviving proceedings in order to sort out the costs.
Yes. Well, in a sense, that was the scenario contemplated by Mrs. Justice May in paragraph 35 of English, where she said she wouldn't discount the possibility of abusive process or egregious or cynical conduct, which would justify setting aside the notice. But in a sense, that brings you back almost in a circular fashion to what is the conduct here?
Well, exactly. So that's why I'm wondering whether your first point about notice really adds anything to your second point about the high threshold.
It's simply the other side of the coin, because there's another
thank you. That's all I wanted to ask.
Just one thing you said before the short adjournment. You referred to the prospect of there being inquests into the extent to which a claimant had complied with the overriding objective. That could only happen if the claim had been struck out, as I read 44.15.
Well, if one sort of unpicks it to give a practical example as to how it might happen, suppose you had a situation where the case proceeds to judgment, but at the same time, in closing submissions, counsel says you should dismiss the claim and you should strike it out because we can point to factors A, B and C which would amount to obstructing the just disposal of the proceedings. So the sort of scenario that the Supreme Court says in Summers would be exceptional but can happen. In those circumstances, you would have possibly not only points made about the evidence in the trial, but what are said to be anterior points going back into the history of the matter to ground that submission. And that would in effect potentially get the defendant home in a case where there was not fundamental dishonesty. Because if they could point to particular factors in their closing speech, there's no reason why they can't run that dual submission. The other point would be the situation where case goes through the process for 18 months from issue through to listing, and then 3 weeks before trial, the claimant serves a notice of discontinuance when the defendant has a substantial bill of cost. If it was open to a defendant to say that there's a broad discretionary power here, then they would dig into the conduct and say, well, you discontinued 3 weeks before trial, but you should have done so a year ago, and therefore to seek their costs for that period. But that would only bite on Mr. Higgins' third submission, that there's some sort of residual discretionary power.
Yes, thank you. Good. Thank you very much indeed, Mr. Higgins. Yes, do you reply, Mr. Higgins?
Thank you, my lord. Firstly, the Starty case, in my submission, that is not a particularly helpful case to analyse for the purposes of giving judgment on this appeal. Followed to its logical conclusion, Mr. Blackledge, if he was a personal injuries litigant, would be permitted to serve a notice of discontinuance, and that could not be disturbed because, to use my other friend's phraseology, there was no legitimate interest in setting aside the notice of discontinuance. I don't understand my other friend to be adopting that position, which would be highly polarised, that in effect there is nothing that can be done ever to set aside a notice of discontinuance. I think everyone must agree that Mr. Blackledge, for example, if he was a personal injuries litigant, and if he discontinued, would be susceptible to having his notice of discontinuance set aside and having his claim struck out. The question for this court is, that's one level on the bar. How far lower can that bar go? Mr. Hogan's secondary position is that that is as far down as he should go. Below that, I suppose, would be MAB, which would be so cynical or egregious. It would be a slightly lower test than simply the Blackledge case. But I say that the test should actually be whether the conduct has impeded the just disposal of the proceedings to a high degree. My other friend complains, well, that could lead to some satellite litigation in some cases. It's fairly obvious, the sort of cases where it would lead to some inquiry. But of course, we do have inquiries in relation to fundamental dishonesty. Fundamental dishonesty, someone discontinues, the court can inquire as to whether the claim was fundamentally dishonest. And if it was, Quox is disapplied, and we do have multi-day trials to determine whether or not a claim was fundamentally dishonest. so that cost protection can be disapplied. In substantial cases where costs are significant, then it is proportionate to have those trials. So
Is there some conceptual reason why the test should be very different, simply because a claim makes it to the point of judgment?
You
see the point I make, that I mean, we could take, for example, 3 points in time. The first would be where sometime during the course of the proceedings, but before the case had been listed for final hearing, there's a notice of discontinuance. The second we could take, for example, as being this case, where it's door of the court. And the third would be when judgment is delivered. Now, from the Quok's point of view, focusing on the last two of those, or the first two as against the last, why should there be some very radical difference in the position of protection as between 4415 and 4416?
So, just so I'm understanding the question.
Sorry if I don't put it well, but in 4416 you've got to the end of a case and the issue is, was this person fundamentally dishonest?
Yeah.
So that's based upon findings of the court, effectively, or the court's perception, because we see that from the English case.
No, because under the practice direction to 44, if a claimant discontinues, a judge can direct that there be a trial as to whether the claim was fundamentally dishonest.
Right. Okay. But at all events, it mostly envisages a judicial determination of that question,
yes,
in one way or another. But my question, which I'm, as it were, throwing out for your comment, is why should it be very different for the claimant who gets to the end of one of those processes to one who seeks to stop before you get into the trial process? Why should the general level of stigmatization of their position be very different?
The level of maladaptive conduct. Well, in my submission, it's the value judgment for a judge to decide whether in any particular case.
No, but if you in the later case, you're looking for fundamental dishonesty, which is obviously a very severe conclusion to draw. In cases of strikeout, one's looking at what we've got in the rules and are trying to interpret just how bad does that have to be,
yes,
in order for the 0.15 rule to bite.
Yes.
And what I'm really asking you is there some reason why we shouldn't look at 15 cheek by jowl with 16 and say, well, it always needs to be pretty bad?
Well, I would caution the court from analogizing between two different rules, albeit separated by cigarette paper in the physical text, and seeking to derive from one assistance in the understanding of the other. In my submission, would not be profitable to consider a concept such as fundamental dishonesty and then look at 4415 and say, oh, well, it must be the same sort of thing because fundamental dishonesty is there. That, in my submission, would be a...
Now, of course, I'm not suggesting transplanting the wording. It's just in trying to understand what the rule contemplated when it's speaking of likely to obstruct just disposal.
Yeah.
What was the sort of thing that was being considered, which is what we have to do.
But it goes back to the concept of, are you deserving of your Quok's protection? So if you bring a fundamental dishonest claim, you're not deserving. If you conduct yourself in a way which obstructs the just disposal of the proceedings, then also you are not deserving of Quok's protection. You're eligible to have it lost. If one looks at the case that my other friend was talking about momentarily, Arrow, we've trampled that down. the Masood case, that so the Masood case, paragraph 71, I think he was inviting the court's attention to. Pull that back up again. I've lost my place. Yeah, forgive me. Paragraph 71 and 73 on page 251. Another friend sought to stand on Masood and say that this built on Arrow and was supported the proposition that Arrow was a statement of Arrow set out the circumstances in which it would be appropriate to strike out, and that no other circumstances would be appropriate. But in 71, the following is said about halfway down paragraph 71 on page 251. The question whether it is appropriate to strike out a claim on this ground will depend on the particular circumstances of the case. It is not necessary for us to express any view as to the kind of circumstances in which, even where the misconduct does not give rise to a real risk, that a fair trial will not be possible. The power to strike out for such reasons should be exercised. So the court there was recognising that there was a level that the bar could be set below Arrow, where the jurisdiction would be engaged. But this does not stand as support for the proposition that it's Arrow or nothing. The discretion is wider than Arrow because of this. Of course, in this case, as your lordship pointed out, what this case is actually about is that the proceedings being having run their course, and so why are we striking out something where we've already got to the end of it? No value or utility in taking that step, which is why we don't need to give any exposition as to when the jurisdiction is engaged. Equally, the Hughes-Jarvis case, well, as my lady said, that is a very stark case on the facts, probably unique, and not a particularly helpful case to be extrapolating in relation to our case, and they're a country mile apart, aren't they? Certainly on the facts and indeed on the topics to be considered. And the other thing that jumps out of all these cases on when can we strike out is that all of these litigants wanted to stay in the proceedings. The court was forcing them out of the proceedings against their will, and the test to be adopted when the court is doing that has to be different in my submission when one compares that to a litigant who has resolved not to continue with their own claim. They are apples and pears, I said before. They're different types of litigants. One is being deprived of a right that he seeks to exercise. The other is not. So to stand on these cases and say, well, these support a certain approach is, in my submission, unhelpful when analysing what to do about Quox in our case. So I come back to the overarching submission. If Mr. Blackledge was a person injury litigant and he would have his notice set aside and have his claim struck out, how much lower does that bar go? In my submission, the proper test would be one akin to the Atos consulting case, where the conduct is such as to impede the just disposal of the case to a high degree. Now, I don't accept what my learned friend says that that's going to generate lots of satellite litigation. There aren't lots of these cases. There are some, but there aren't lots. And even if it did generate some litigation, it's important that litigants who conduct themselves in a way that makes them eligible to have their claims struck out and to be deprived of Quox aren't able to wriggle out of that position by serving a notice of discontinuance. That is, in my submission, that is antithetical to the overriding objective, and that is what the court's concerned with here. We come back to the approach that I invite the court to adopt. It should be a holistic approach, drawing upon the overriding objective, drawing upon 3.4, 44.15, and 38.4, sorry, not 38.4, and using those rules purposively, coagulating together, simultaneously, to achieve a just result, rather than looking at them individually and mechanistically, and saying, well, that doesn't work, and this doesn't work, so I can't do what you're asking me to do. That isn't, in my submission, how one should approach interpretation of the civil procedure rules in the modern age. And if, as I say, it's a matter for the court. So the question then would be, on the facts of this case, wherever the bar is set, should this claimant have been struck out? My submission is yes. Mr. Hogan says no. It's a matter for this court to determine that. Can I just say one final thing, unless there's anything particularly that the court has for me? I do have one additional case, if I can hand this up, one that my ladyship again was involved in, very, very busy. So this is a case of Woodward and Phoenix. It simply stands as some support for the proposition that there is no duty of care in litigation and no requirement to warn the other side that they are heading for a crash. And sorry, look, I've got three cases. I'm not going to take the court to any particular paragraph, but it does stand for that proposition. So I invite the court to approach this case on the basis that the defendant did something wrong in allowing the claimant to run his case in the way.
And the paragraph on which you rely is?
So there is a very long extract of paragraph 15 where the judge's judgment is recited. And the long and short of it is that those comments were endorsed. Paragraph 51, the conduct of M&R or Phoenix cannot be characterised as a breach of CPR 1.3 duty to warn CB of defect in service. That was a case where there was defective service and the defendant kept quiet. And the claimant said, well, you should have told me.
Yes.
Can I assist any further?
No. No, thank you very much.
Thank you very much.
Well, can we thank you both for what I respectfully say has been a very well argued matter. We'll obviously take some time to consider our judgments and let you have them in draft for a fairly swift turnaround, identifying our editorial shortcomings and presenting us, please, with what one hopes will be an agreed draft order to reflect our decision. And once that's happened, we'll hand the judgments down electronically in what's now become the normal way. Was there anything else?
Thank you very much.
No. Thank you.
All rise.